Hello, Claire.
Hi, Anne. Good day.
What is the English law approach to force majeure?
Today's world has seen and continues to see events which are uncontrollable, unforeseeable, unavoidable, and which can cause havoc with normal business planning in the world of shipping and trade. I'm talking wars and geopolitical tensions, labour force shutdowns, government export and import controls, extreme weather situations such as floods or wildfires. To mitigate the effects of these type of events, in English law contracts you'll often find an FM clause. It's very much a contractual provision, so it must be set out in a contract to apply. This is different to the English common law principle of frustration. Frustration is rare. It requires an unforeseeable event which makes the contract impossible to perform, or the performance to be radically different to what was agreed originally. That doesn't mean more expensive or more difficult, and it's a very high threshold. In contrast, an FM clause in a contract can be more widely used. What event it covers is going to depend on what the clause says, and it's an exclusion clause where one party's performance of a contractual obligation may be excused. So, as an exclusion, the contract FM clause will be strictly interpreted. It's important, therefore, that it's clearly worded and covers the effect. If an FM event occurs, what do we look out for? Is the event one that is expressly listed or part of a description set out in the clause? To what extent does the clause say performance is prevented or suspended, and whose performance is affected? Must the performance be prevented or delayed? If prevented, that points to legal or physical impossibility. And some clauses will have a requirement for reasonable endeavours, and there's been some debate about how far that goes. Look out also for clauses that might not be called FM. For example, GAFTA standard form contracts used in grain trade has prevention of shipment clause covering issues of government export controls and workforce strikes, for example. FM clauses usually set out strict conditions. For example, notice in writing, sent within X number of days of the event, and continued updates, perhaps supported with evidence and an expected timeframe. And a good FM clause will spell out when a contract becomes terminated if the event continues. All sounds good, but even a perfectly worded clause will only assist so far if that's not repeated in other related contracts. Something to watch out for when looking to minimize your exposure in an FM event.
Thank you so much, Claire. Bye-bye.
Thank you.